Now, Ms. Freeman, Ms. Strother, and whoever else you might have with you or are including, will you please give us a brief presentation of what's happened in your world?
Sure. Thank you, Madam Chair and members. My name is Nicole Freeman. I'm the Government Relations Director for the Secretary of State's office. I do have Julie Strother as well as BB Black, our General Counsel, on just to help answer any questions that come up. I think my presentation will be pretty brief. And then you can move on to the rest of the business. Once the redistricting plan was enacted, Minnesota Statutes 2.91 provides a process for the Office of the Secretary of State to issue corrections to the plan under very limited circumstances. And so the most common reason that we would issue a correction order was when the description of a district boundary line is ambiguous or it wasn't properly named. A common example of this is when the redistricting plan specified that a whole jurisdiction would be within one legislative district, but the census blocks don't perfectly follow that district line. And so in that circumstance, we could make that technical correction where they determined, because the redistricting plan stated that it wasn't a split district, it was a jurisdiction that should be complete in one House district. So counties and municipalities, they submit these boundary correction orders to the Secretary of State's office after they've reviewed the redistricting plan themselves. And then the Office of the Secretary of State reviews the correction requests to determine if they meet the requirements set out in 2.91. If they don't meet the requirements in 2.91, jurisdictions would need to seek legislative approved changes. And so some of those changes are, some of the changes you're considering today are ones that OSS is not permitted to make or didn't have the authority to make under 2.91. So if the Secretary's office does determine that a correction request meets the requirements in 2.91, we are then obligated to consult with the reviser of statutes as well as the Legislative Coordinating Commission before issuing a correction order. So we consult with those two groups to make sure that that they also believe it fits 2.91, as well as that our fix matches up what they feel like it should be as well. So the Secretary's office has currently issued 8 correction orders under its statutory authority, and the correction orders are available on our website in the official documents database. These 8 correction orders are less than half the number that we issued in 2012. I was talking with Brad Newhouser in our office, who does a lot of our GIS work around redistricting and working with the cities and counties, and he thought that reduction in number of correction orders was likely because the mapping is just better. That mapping technology has improved, and so there's less little movement between lines that are needed to be made. So that is those are the correction orders that the office has made thus far, and the rest of them would have to have any legislative action taken.
Okay, Representative Torkelson.
Oh, thank you, Madam Chair. And for the testifier, is there a time limit on when the Secretary of State can make these sorts of corrections, or is this an ongoing process?
Ms. Freeman.
So I don't believe that there's a time limit set out in statute. Many of them, though, historically have happened prior to like the beginning of candidate filing, for example, in past years. So these correction orders were issued March 31st. Yes.
Thank you.